All right, welcome to the Getting Divorced Without Losing Your Mind podcast. This is Corey Shapiro. I got a special treat on this podcast. I have a conversation with Ron Bavero, who in my world is a red belt. He's a divorce master, and he wrote an amazing book. I actually have it right there, right on my bookshelf. I took away my book, put his book, because his book is great. It's An Elephant Doesn't Marry a Giraffe. So welcome, Ron, to the show.
Thank you very much for having me.
Well, first of all, I want to know how you came up with such a creative title. But before you do that, I want to read a book review I found on your website, Divorced Ever After. Here it is. This book is a must read for anyone facing that supreme out-of-body experience called divorce. Takes you on an enlightening and highly entertaining journey across the deep sea of divorce, replete with warnings about the depth charges lurking beneath the surface. So, Ron, how did you come up with such a great title? And tell us a little bit about your journey becoming a first-time author.
So the title actually has its genesis in a phrase that most matrimonial attorneys are familiar with. It's one that we use frequently to deal with the attorney on the other side who is suggesting that your client really is making this case just way too difficult, is not acting appropriately. And so the response that was fashioned a number of years ago by a very famous matrimonial lawyer was, yes, well, if that's true, just remember an elephant doesn't marry a giraffe, which is a nice way of saying that your client is not exactly a trip through the woods either. So that's as I said, the genesis of the phrase.
Yeah, and tell me a little bit about your journey becoming an author for the general public.
You know, during the course of my life, apart from my matrimonial practice, I've always enjoyed the opportunity to teach. And I did teach both law school and undergraduate. And I really loved the interaction with students and the ability to pass along information to the next generation of lawyers. So that combined with the fact that I really enjoy writing in general. I mean, in my practice, and I'm sure in your practice, you know that you have to write a great deal. And it is a very significant talent to have when you sit down and have to try to convince your audience. And in this particular case, and in many of our cases, we're speaking to judges, trying to, number one, get their attention. Number two, convince them as to the correctness or rightness of our position. So that skill of trying to convince and convey your client's position has always been near and dear to my heart. And writing, therefore, became a natural outlet for me. I actually started this book a couple of years ago. It went through various reiterations. In the beginning, it was just a series or collection of stories, true stories, you know, from all of our respective lives and practices. But after I finished that first version, I then started to think about the fact, well, you know, the stories are great, but, you know, what's the point, so to speak? And so in my second version of the book, I took all of the stories that I had used, many of which are interesting and amusing, and used them as a platform to talk to divorcing parties, to talk to lawyers, to talk to judges, and, you know, the whole panoply of people that we find in our cases about what they need to know about the process of divorce, what they should be doing, what they shouldn't be doing, the critical errors they make, the shortcuts that help people navigate the process in a much more efficient and less costly way. And so that became my mission, if you will, to, you know, reach out to people who are going through this terrible process.
I mean, your mission was achieved. I mean, what I loved about your book is, first of all, I felt so a kindred spirit to you because you said the true function of a divorce attorney or one of the main true functions, is to rein in a client's worst impulses. And I think through these stories, you really help teach us to do a better way, because you could see what not to do in some cases. Also, it's, you're right. You've honed your writing skills, and it's like a comedian, when you go up there and it just flows and it's easy and it's great. So it's so easy to read, and your stories are just fantastic. So I think I would, highly recommend this book to anyone, unfortunately, who's in the situation of getting a divorce. All right. Your subtitle of the book, which I like, and it's a big offer. You're saying everything I learned as a divorce attorney, you're going to give us in this book. So I'm going to ask you some questions, thinking really about an audience who's starting this process. So let's start off what I think is the beginning of where people think about attorneys is really in a prenuptial agreement. I would think that's the first time they think about an attorney. So what are your thoughts? First of all, what is a prenuptial agreement for people who don't know? And what are your thoughts about them?
All right. A prenuptial agreement is an agreement between the parties in contemplation of marriage, where in anticipation of their life together, they have the very conversations that they should be having at that time, as opposed to having them in the midst of a breakdown of the marriage when everyone is fighting. In the beginning, when people are approaching the process of marriage, there are some very important discussions about what we're going to do, how we're going to comport ourselves as a married couple, what are our expectations of each other, how are we going to handle finances, how are we going to handle, when the time comes, the question of estates rights and those kinds of things. So in the main, it's aimed at the economic issues that the parties may reasonably expect to come up during their marriage. The important and interesting point is the parties can't make an agreement about children yet. Obviously, they don't even have children yet, or frequently don't. But the court does not allow parties to make contractual agreements with respect to custody. So it very much is an economic document. And I know that sounds kind of cold and perhaps unromantic, but that's what it's intended to do. And I'm sure that you've had your experiences with prenups, and I've had them as well.
Yeah. Do you have any recommendations or suggestions for people who are thinking about prenups? I mean, I understand it's an economic agreement. I mean, I agree with you. It's so much easier to deal with these issues when everyone is in love versus the bad blood on the other side of it. But is there any suggestions you have for people who are thinking about a prenuptial agreement?
In advance of the marriage, people should be having lots of conversations about how they see their marriage and what their expectations and responsibilities are in terms of that relationship. So that's the beginning of a discussion. But a lot of times people avoid the economic conversations. What are we going to do if, God forbid, the marriage doesn't work? How are we going to divide up our assets? How are we going to provide for support for each other? Those are economic conversations that they need to have. And it is critically important that the parties contemplating prenuptial agreements, get assistance from independent counsel. They need to have, each of them need to have an attorney to act as a sounding board to discuss some of these issues that they may not have even thought about, and offer guidance to the parties about the various paths that they can take in resolving these issues. So getting into the hands of a good matrimonial attorney, or family law attorney, may be more appropriate term, is critical in the process of executing a prenuptial agreement. And the next thing is, don't wait to the last minute. I can't tell you the number of times that people have called my office or tried to schedule an appointment, and they say to me, the wedding is at the end of this month. that's a bit rushed, shall we
Yeah, I've
say.
gotten those calls, unfortunately.
So having those discussions sufficiently far in advance so people don't feel intimidated or under pressure to, enter into this contract.
Yeah, no, I totally agree. It's in popular culture, it seems like we focus on the romantic aspect of marriage, but it's really a business relationship in some respects. And I think talking about the financials early on is very helpful. Your book, and I'm sure just who you are as a person, you come up with these wonderful phrases, and I'm going to sprinkle a couple to tease you how good Ron is with the turn of a phrase. But one thing I want to talk about is now you got the prenup, and now you have the wedding, and I thought it was really hilarious how you're talking about how the vows are aspirational, and I think one. Yeah, and I think one thing you said was, here's a quote. I think it's, I'm only staying for the better or until I find better. And I was like, that is just so true.
Yeah. Yeah. I mean, that's a bittersweet topic, as you can imagine, because one of the things that really impacted me when I did this work is that we see people at their worst moment in time. And when you see people with the level of anger, rejection, hatred toward the other person, it really tests your ability to understand how these two people moved from the loving ceremony that most people end up having at the beginning of their life together. That, they couldn't imagine being apart from each other. They couldn't love anyone more than they do. And somehow between point A being the marriage and point, Z being the divorce, it's all gone wrong. And so I found it always so difficult to wrap my mind around how did they get from these 2 points.
Me too, Ron. I always think about that as well. It's crazy. It's crazy. You talk about in your book, which I love, and I know exactly what you mean, the difference between the planners who are thinking about getting a divorce, and then the people who are surprised. And tell us a little bit about that experience with representing those.
In my practice, I saw this frequently, that people generally fell into one of two classes. There were the planners who knew they wanted a divorce, scheduled a consultation, and were basically there to get information so that they could prepare their divorce case, line up the attack, so to speak, get everything in place, start setting up new accounts, possibly, doing things to hide money, doing all kinds of nefarious things. And then on the other side, I frequently saw people who came to the office and said to me, this divorce and separation thing came out of nowhere. I had no idea that my spouse was, contemplating it. I was shocked when my spouse said, I want a divorce. And so you have these two groups of people. And unfortunately, the ones who find themselves in the category of being shocked or stunned, those are the ones who really need some guidance because they haven't been thinking about divorce and they have no idea where to begin. And so this book, in a very real sense, is a roadmap, is an ability to say, okay, I know that you are in a place that you did not want to be. But given that seems to be in a reality, you need to come up to speed pretty quickly. Because if not, the other side's just going to run you over. And so the ability to find a resource that step by step can take you through the process and help you avoid the major mistakes that many people make in their, divorce cases, or to give you the ability to have some confidence that the decision that you're making is a good one. I think that that's what this book speaks to.
Yeah, I mean, I've done a mediation where, one person is crying for 15 minutes about all these emotional issues. And then literally when I ask what's important to the other side, they literally bring out like an Excel spreadsheet. And bringing those two people together is a challenge in a divorce. So I think what I like about your book is when you're in that highly emotional state, you sort of like reminds me of how to give vegetables to kids. Like you've made like a brownie, but it's really zucchini brownie. It's easy to, the kid's like, I don't want to eat any of that zucchini, but it looks like a brownie. And I think your book with those stories and your humor make a very difficult time a great entryway. And if
Yeah.
you're thinking about a divorce, either way, process or you're surprised, one of the first things to think about is the process choice. And you maybe have heard, if you Google or around or just talk to people, there seems to be three main choices, and I want you to discuss those, which are mediation, collaborative divorce, and litigation. If you can explain what those are and what maybe are the pros and cons of each.
Okay. So the traditional approach to a divorce case is each of the parties goes out and hires their own attorney with a view, hopefully, of resolving the case without any acrimony or litigation. Sometimes that works, sometimes that doesn't work. Sometimes, as you probably know, having been in this field for years and years, they turn into the, god awful litigations that just unravel a person's life and make it so difficult.
Yeah.
So the traditional approach, where each party has their own representative, hopefully is something that people can build from in order to reach a settlement. That's the ideal. That's not always the end result, but that's the ideal. Another possible approach is the process of mediation. So mediation involves basically taking the court, if you will, out of the equation. And in place of the judge, putting a mediator who often is an attorney, but doesn't necessarily have to be, and has the ability to speak to the two parties about how they want to resolve this matter. And very frequently in that process, the parties don't have attorneys appearing at the actual mediation sessions. They may receive information and may get counsel of their own choosing as they go through the process. But very much the process is the two parties speaking to each other through the mediation process to resolve the matter. Another construct is arbitration. So again, arbitration moves to the next level, which is we'd like to resolve our case. We don't want to go to court because it's too expensive, because it'll take too long. And in place of the judge, we will have an arbitrator who is in fact someone who will make legal determinations and can make binding decisions with respect to aspects of the case. They can help the parties resolve the equitable distribution of assets or child support or maintenance. And it's a much more formal process. It's outside of the courthouse, but the person has quasi judicial powers, the ability to decide things. And the benefit of that one is that while the parties do have counsel and are going through this process, it tends to be much quicker and much less expensive.
Yeah.
Even though the parties are now paying both their attorneys and the arbitrator. I guess the final thing I wanted to talk about is collaborative law. So collaborative law is that the parties go out and they obtain the services of their own individual counsel. The people who are representing them are in fact called collaborative attorneys. And basically, the four people, the two parties and their individual counsels, enter into an agreement to resolve the case. And so, they may in fact go through the case by hiring experts who can give input on important decisions like the value of assets, value of companies or practices, or those kinds of things. They may bring in an expert to deal with custody, to make suggestions about how the parties may want to handle it. But there is a commitment by the four people that we're not going to litigate. This sounds overly simplistic, but there's a truism. You can only be half of a divorce case, And if the parties are going to be cooperative, if they're going to approach the process from the perspective of, we know the marriage didn't work, but we want to move past that and we want to do something that makes sense for each of the parties and any children that, are the product of that relationship. If the party's mindset is that, any of these processes will work. Right? Whether it's collaborative law or two attorneys, who represent the parties, and are not necessarily collaborative lawyers, mediation, arbitration, any of those will work when you have two parties rowing in the same direction.
Yeah.
The problem becomes, what happens when they don't? What happens when we reach the impasse or the point at which we don't think we can go beyond that without some help and some judicial intervention? It's nice in the collaborative sense that the parties have agreed to enter into this agreement that we're not going to litigate. But at the end, if the parties reached a point where, we've reached an impasse, we can't get past this issue on whatever it is, then the downside of collaboration is that you then step out of that process and hire your own attorneys and start all over again.
Yeah.
And so there is a tremendous economic, impact if the parties don't reach yes. So, that would be my view from 50,000 feet,
I always tell people an agreement is only as good as the person you enter into it with. And the sooner you can determine the correct path based on the level of cooperation and collaboration, the better. Because if you do a collaborative divorce or a mediation and it's a manipulation, then as you said, you're just wasting time and money. On the other hand, you don't need to, fire all missiles and go to court if you could, just call up an attorney and have a nice, quick agreement, which happens often. So let's get into this a little bit, Ron. You said one of the most valuable things you provided as a divorce attorney, and I think in your book, the same, is the consultation. So discuss the consultation with an attorney and maybe three things of value that people who are maybe interviewing attorneys or have never been to a consultation, what should they be getting out of it?
So you're right. I said there's no good money spent in a divorce case, but the most valuable money often is the consultation.
Yeah.
Because a good consultation by a good attorney will get you kind of well set up for what you should know and how you should be approaching this case. And a bad consultation may just elevate the expectations of someone to impossible proportions, which ends up, thereby costing that person dollars and thousands of dollars, unnecessarily. So consultation. Number one, I think that the consultation is valuable because you're sitting across from someone and you're getting a sense of who they are and how they view life. And in this particular area, it is particularly important that you retain someone that you trust, that you like, that you have the sense will guide you appropriately. And P.S., someone who may not disagree, may not agree with you all the time and may talk to you from the perspective of this path that you're pursuing is not a good one. It's fraught with disaster. So the ability to sit with someone in the consultation and get a sense of who they are, how they operate within their cases. Are they people that, in fact, do want to resolve the case? That's an important consideration. But as I say in my book, it's also important to know whether this person could take this case to court and or trial if necessary. Because if not, there are these kind of tragic situations where somebody's represented for years and years by attorney A, only to find out that when the case is scheduled for trial because it can't be resolved, there's going to be a new attorney in the case called trial counsel who now has to review everything and double the cost of the litigation. So going back to the consultation, because I'm jumping ahead, sitting with the person, getting a sense of who they are is important. Secondly, listen to how the person explains the process to you. Are they clear in terms of the various components of the process? How do we divide assets? What are we doing about, child support and spousal support? What are the alternatives for custody? And if there is an issue of domestic violence or, some real difficulty, physical difficulty in the relationship, the attorney needs to speak to that as well, because that's an item of protection. So your attorney, in terms of how they discuss the topics with you and how clear they are or not clear they are about the various component parts, that's important. And I think that, and I did say it in my book, one of the things that I promised myself when I started this work is that I'd always in the consultation give somebody a realistic, almost brutal sometimes, view of this case. Because the facts are the facts and the truth is the truth, And I hated attorneys who would basically sugarcoat their advice or, say what the client wanted to hear simply to get the case in the door. Okay. Because there the client is, going to be pursuing unreachable goals and spending way too much money on this. Being honest with the people is important.
Yeah, I mean, what you're saying is so valuable, and that's what I got from your book, and that's your reputation. I mean, you are a true trusted advisor. That's why you get the red belt. That's why you're the master, and that's what you want early on. We're advisors, we're counselors first, and we have to put the clients ahead of our own self-interest. And I think that's what makes you really great. And I think that comes off in this book, that you're just trying to be a trusted advisor and give people options. Yeah. And the other thing about hiring an attorney who actually can try cases, if that's the path that's unfortunately go to, I think that's a big thing, because if the attorney is really scared of a trial, that might really influence negatively settlement positions. And I know in your book, I got a sense that, you weren't scared of going to trial. You would prefer to resolve cases, but if someone was going to be really unreasonable, really difficult, you had to do what you had to do. Just like I'm assuming a doctor doesn't really want to do surgery on you, but if they have to, they will. And that's what we pay them for. So I thought that was really great, Ron.
That's a good way of explaining it.
Yeah, no, thank you. Well, you're inspiring me from your turn of phrases. So there you go. I play tennis, and when I play people who are better, they make me better. So I feel like I'm playing above my level with you, Ron.
All right. Not at all.
All right. So now you had a consultation. Maybe you had two, and you gave some guidance. And then now you're picking, let's talk about picking the right divorce attorney for you. And I thought you had a great line. So here's another one. says a good lawyer knows the law, a great lawyer knows the judge. So how important is it that the attorney really appears regularly before a judge if you have one of those contested cases?
I think it's very important that attorneys appear in front of judges all the time. And it's important that you retain somebody that has the respect of the judge who's ultimately going to be trying the case. That doesn't mean they're going to agree with me about everything. You know that's something that's not in our reality. But the fact that they respect you as an attorney and advocate is important. And so you find that many attorneys confine their practice to particular areas or counties and are constantly appearing in front of judges. I think there is a definite benefit to that. Now, I'm not saying that, I couldn't come to New York County or you couldn't come to Westchester and do very well, because judges, even when they have attorneys from different areas, are looking for someone that they can work with, someone who respects their rulings, someone who makes intelligent arguments. And so if you're that kind of attorney, you're going to do well no matter where you go. But selecting the proper attorney, or the best attorney for your case, is the way I say it, is extremely important. And in my book, I talk about a conclusion I've come to over a number of years. People hire who they are. So what I mean by that is, if someone is what I'll call Wall Street wise guy in the finance area, who's used to getting his way or her way, and who's used to running over people in the process, well, guess who they're hiring? They're hiring one of the more aggressive people that they can possibly hire. And say, if the wife is a very studious, amiable person who wants to get the case done and doesn't want a lot of argument and fighting over this, well, guess who, that woman is hiring? She's going to hire the studious attorney who wants to get it done. That's all well and good until, as I say in my book, until Miss Holly Golightly's attorney meets Attila the Hun's lawyer,
Right.
And things don't work as well. And so one of my critical pieces of advice is not to hire someone who's the alter ego of you. Rather, hire someone who can handle your spouse.
Yeah, that was such
who
a
has
truth.
no difficulty, standing up to your spouse. And that's very important.
That's so important, Ron. And when I read that, I was like bullseye. I mean, that's it. That's like, gets the prize. That's the answer. All right. So let's say you hired the attorney. You're now starting the process, and maybe you have a settlement conference. You discuss a settlement conference in your first chapter of the book. And it was kind of funny listening to this attorney seasoned attorney with a big firm, and basically didn't even think he needed you in there, and sort of took over and things went sideways. So can you explain, first of all, what a settlement conference is, or maybe what we would call a four-way to people who have never heard of this? And how do we act, not how lawyers act, but how should clients act in these settlement conferences?
Okay. So a settlement conference, as the term suggests, is an opportunity for the two parties and the two attorneys who represent them to have a meaningful discussion about the resolution of some or all of the aspects of the case. Conferences frequently happen in attorneys' offices, one attorney's office or the other. Sometimes they happen at the courthouse in the context of, court conferences. That was in the period when judges used to actually preside over cases and participate in settlement conferences, which I think unfortunately is less and less these days. But a settlement conference, as I said, is the opportunity to talk, to sit down across from each other and to have candid discussions about the issues in the case. Sometimes I think that attorneys look at it from the perspective of all or nothing. Well, that was a failure because we didn't get to yes on all the issues. And instead, I think that it's a building process. You start with, conferences, settlement conferences, and maybe you resolve 2 or 3 issues. But that's an opportunity to build on that. Yes, we may have some issues that we still have difficulty with, or may have to get input from, the mediator, from the arbitrator, from the judge. But it's more important that we begin the process of agreeing on things. And so I think that's critically important.
Yeah, I like this idea of building momentum, because I definitely have that feeling that if it is, if it's not settled, the major issues are not settled, it's a failure. And it's nice to think about that, even if you can resolve just, smaller issues first and build that momentum. So I think that's very good.
You asked another important question, which is, how do you prepare the clients?
Yeah.
And so at the beginning of the book, I talk about my experience of saying to the very quiet, gentlemanly lawyer who I represented, let me handle most of the discussion. If you think you can resolve something, feel free to, to jump in. You do want to have that conversation with the client that says, listen, I'm here to help you. Let me do what I'm supposed to do. That doesn't mean you have to ask my permission to speak, but let's make sure that, this is an appropriate time to open this aspect of the conversation. And from the book that in that particular case, the attorney, who was always, the epitome of decorum, ends up saying, well, if that's your position, there'll be blood all over the floor. I mean, and I had to take him aside and say, that's just not the phrase that you might want to use in a settlement discussion. It just puts a negative pale over it, and he apologized.
It's a nice understatement, Ron. You had a good soft touch with him. It was kind of funny how quickly, and we all know this in our personal experience, where we go from 0 to 100 really quickly, and it seems that's what happened to him. There's a lot of probably internal things that he was holding down.
Yes. And there's no question that the other side, and I had prepared him for this, the other side is also testing your client to see, are they pushing buttons? Is there a hot issue in there? Is there something to be exploited? So, while we're having a settlement discussion sometimes, people are still using it as an opportunity to size up the other client or you and how you handle issues. Are you going to be prone to the immediate blow up? Well, if that's your position, I guess we have nothing to talk about. So it's an interesting, I guess the word is dance. It's an interesting dance that we do, when we sit down to resolve a matter.
And it's a learned dance. It's like tango, it's like a lot of steps involved, to do it right. And once you get it right, then it's really beautiful and smooth. But in the beginning, it's difficult, like that example you gave. All right, let's talk about a tricky issue you brought up, this syndrome that seems to affect a lot of people going through a divorce. I don't know if people have heard of it. You're going to explain it for us. It's RAIDS, or recently acquired income deficiency syndrome. So tell people about why everyone who gets, or a lot of people who are going through divorce have this syndrome, and what's the cure.
Well, that expression has become an important fundamental issue in matrimonial law. So let's explain what RAIDS is. RAIDS is recently acquired income deficiency syndrome. And we usually find, the classic example may be the husband owns a business and it's doing really well. and it's funding a wonderful lifestyle for the parties and the children. And then the divorce starts. And suddenly the business isn't doing so well.
Right.
And, the husband is finding it difficult to make ends meet, and the business is going to go under. And this is, part of I'm searching for the appropriate word. The process where the attorney on the other side is basically trying to devalue the interest in the business and suggest that it's not so great. And of course, on the other side of the case, the party who's the non-titled person, they're claiming, look, this business is great. It's doing, maybe doing badly now, but that was just a divorce, and it's going to make millions and millions of dollars. And so within the context of bringing in valuators, forensic accountants to value this, the expression is, you ask a, forensic accountant, how much is 1 + 1? And he says, how much do you want it to be? So on one side, the husband says it's worth nothing, and the wife says it's worth, $15 million, and so those are some of the issues that come up, in the context of our matrimonial litigations.
Yeah. And that's, I guess, why these experts are important. If you do have one of these cases where the income is not kosher, I mean, you have to have proof for the court. Experts are expensive. Attorneys are expensive. Hopefully you don't have that situation, but you got to really roll up your sleeves, I think. And it's sort of like, show me the money. So sometimes it could be tough. One thing you did, I think, really good in your book and obviously in your practice is your ability to use humor to really be persuasive, to teach, to diffuse situations. And, I think in your example in that first chapter with that gentleman who was so triggered, he wasn't able to use any humor, and things fell really flat and really escalated. But you have a part in your book where I think things weren't going well for you in court, and the judge was getting mad and maybe getting loud. And you said to the judge, and this is how you diffuse, this is how a master does it. You said, Your Honor, please, I'm just stupid. I'm not deaf. And when I saw that, I was like, first of all, I'm glad Ron gets beat up because he's a master and we all get beat up, and that's great. And second, that's how you come back to a judge in a way that's respectful. So first of all, kudos for you for being so persuasive. But secondly, how can you convince, these clients or teach these clients to be more persuasive? Maybe, in a co-parenting situation, maybe even with you or going to court, because in my experience, a lot of it comes down to what you said. It's a court, it's a court. You only get a fair chance at a shot, it seems, if the court is not really mad at you. If the court's mad at you, that's an uphill battle. So how can you keep, at least on the court's, semi good terms?
I think what's critically important, and you alluded to it earlier, is while we're advocates, we're also counselors, and I used to love that appellation when it was used previously. We were counselors at law. And so counseling the client is probably the most important critical thing that an attorney does, right? And when the party is about to, let's say, testify or appear before the judge at a conference, that person must come across as reasonable, willing to negotiate, willing to concede when they're wrong. These are critical things because judges, they've been doing this for a long time, for better or for worse in some cases, but the really good ones, appreciate that someone comes from that perspective and is willing to negotiate. And so when we talk to them, I think I even titled it, a chapter heading, and the chapter heading was, dividing the assets. um, pigs get fed, but hogs get slaughtered. And that's really meant to convey, if you're taking overly aggressive positions, if you're taking positions that you may think, are important to you, that's the bottom line for me, I'm not going to negotiate below that. If you're doing that in an intransigent way, you're going to get hurt in the courthouse, you know. And uh, the famous expression that we all use, is, there's a son of a bitch rule, where if you're that person, the judge is going to take it out on you, whether you're a man or a woman. If you're the overly aggressive person, if you're the person who just won't compromise and has to have it their way, not going to play in this forum, in this courthouse.
Yeah, those are wise words, to be flexible, to show that you're willing to do everything possible to avoid a trial and to be clear in your positions. I think that does go a long way in most cases with the court. And then maybe the court will see the other side's being really difficult and extreme, and maybe that will help you. So that's great. That's great information, Ron. Let's do a creative approach. Let's get into something that maybe people can do. I love that chapter you had about dividing property and that creative judge. I think it was a judge who came up with it about doing, you remember the 2 lists method? The judge said you could draft a list of all the property you want to divide. You'll divide it on 2 lists. And then the husband, husband gets to pick one or other of the lists. And I thought that was a great way of doing it because, you gave all the power to one party and they're like, wow, this is easy. But then when you listen to it.
And that comes really out of the experience that at the end of every matrimonial case, and I said it early in the book, I can divide $50 million more easily. Dividing up $50 million worth of assets, not a problem. Okay. A lot of money to go around, a lot of assets to go around. The most difficult part is dividing up the contents of the house. Okay. And so, and judges hate doing this. I mean, we hate, doing this, but judges certainly hate, getting into the personal property disputes. And I have some examples of it. And one of the examples was, that the parties couldn't reach an agreement on the personal property. And the judge says, well, ma'am, you make up 2 lists, any way you want, put as many assets on one side as the other. And then I'm going to give your husband the first pick, which is, I'm sure all of us think back to our childhoods with our siblings, when mom said, I'm going to split this icicle, and then, one of you is going to get to pick first, so, it's an interesting way that judges find to deal with an area that they don't like doing.
Yeah, no, it's very smart and very creative. And if you can step back and be creative, like for example, in my household, my wife hates making the bed, hates it, but I always get up first. So I never make the bed. And we have a dog, but the dog has to get walked. And I used to walk the dog every morning because I'm the first one up. So it took us years to figure out that I would make the bed, which is easy for me to do because it's, it's not a stumbling block for me. And she will walk the dog. That took us years to think about in a calm, loving situation. So when you're in these difficult situations, it's nice to have a smart outsider like that judge or maybe wise counsel to think of these things. So you don't have to spend.
Well, Corey, in your case, you could have provided for that in your prenup. And indeed, some of the prenups are that detailed.
Okay. Not the prenups I do. I do very basic, but yes, more evolved prenups. You can get very detailed. Okay. Let's talk about bigger picture here. Let's talk about some key mistakes parties make when getting divorced. Give us some key mistakes you see.
Well, certainly we touched on one of them, which is over aggressiveness in your settlement positions. another key one, and it plays out particularly in the area of custody, is not bad mouthing the other side. Whether we're talking about, how to divide up assets, or we're talking about custody, denigrating, bad mouthing the other side never, underscore the word never plays out well in the courthouse. And so, to walk in and say, as some clients have done, she never worked. She just took care of the house. That phrase used to, I would cringe and I would say, it's a good thing you said that to me and not the judge. Okay. Because the judge would hand your head to you for saying something like that.
Yeah.
But denigrating the other spouse to the child, judges really look disfavorably on that and will take it out on that parent, when it comes time to make decisions with regard to custody or visitation. So denigrating the other side is also something. I guess the other thing, and it kind of fits hand in glove with something we talked about. Sometimes people say, I've got to have this thing. I don't know what the thing is. It could be like the case in the book where the guy had to have the Volkswagen, Beetle. Or the thing is, I have to have more overnights than you have, When the party, settles into their I must have, it represents an opportunity for the attorney to really talk to them to say, I know you think that that's the case. I know that it is important for you, but you're going to pay a very steep price for maintaining that position. Because, the judge is not going to like it, or the arbitrator is not going to like it, or the mediator, whoever. So locking into positions. And, I used to find this particularly when we talked about legal fees and stuff, and somebody would say to me, I'd rather spend, 50,000 on legal fees than giving up, this issue. And I actually use this line a number of times with my clients. And it's like, this is a bad idea. Don't do this. Do you want to put your kids through college or do you want to put my kids through college?
Yeah.
Whatever you like to do, but it's a bad idea. So, it takes the attorney to discuss and be firm with, what they perceive to be an errant path. And it takes the client to recognize that the advice of the attorney in this regard is something that they need to understand. And sometimes it takes a little bit of time. You and I don't speak to clients and they go, oh, I never thought of that, or, oh, what a wonderful insight that is. Sometimes it takes repeating and a little bit of digesting before the client finally gets it.
Yes, that's 100% right. Over communicating in a skillful way. I love that idea about not bad mouthing a spouse. I mean, about a co-parent, because the time frame with child is well past a divorce. And even if in a nasty divorce years, we're talking a child, it could be your whole lifetime, and you're just paying dividends in the future if you can think long term. And I really like that idea. And I think that's why you really speak to me about being that trusted advisor when someone gets, position polarization and they're not going to win. I have a 20% chance or a 10% chance of winning. But they're losing. They're going to lose. Even if they may win, they're going to lose. It's not going to probably be worth it in most cases. So I really appreciate that, Ron. All right. So let's leave this with, you end your book, or one of your endings in your book is how to move past this divorce. And I think a more difficult divorce in a healthy way. And I think a big challenge we talked about early on is the people who are surprised, surprised by the divorce. Maybe they haven't had an opportunity to grieve. I understand it takes a few years potentially to grieve in serious cases. So what can people do, especially these people who were surprised and maybe their grief has been on hold, and now that, maybe the divorce is settled, and as you said, no one necessarily wins a divorce, they survive it. But how can they move on in a healthy way so they can move on to a better life?
That takes a lot of work. I read once that divorce is the second most stressful event that one can go through in their life, behind death of a spouse or a child. And it's less stressful, believe it or not, according to the survey, than going to jail or being in a car accident. Those are deemed to be, even more less stressful than going through a divorce. Imagine that. So let's recognize that it is a tremendously stressful, difficult thing. How do you get by it? Well, you need a team. You need help. You need a good therapist. You need someone to help and support you. Hopefully, there are family members who can provide that. You need a good deal of reflection, and you need to take, in the case of parents, a good look at that child who you're raising. And you've got to be able to say that they will only recover from the aftermath of a divorce if you recover. If you don't recover, they're not. If you can't go on, they can't. And that's a very important reality. And I think people sometimes don't appreciate or focus on that, how important they are to the survival system of their children. And so, I really commend people who walk out of the experience, with their heads held high, saying, I did as good as I could possibly do. I want to move past this in a healthy way, and I'm going to help my children, if you have children, do that as well.
Yeah. Great wisdom, Ron, you're sharing. Thank you for that. Thank you for this conversation. And you see his book right behind me, available on Amazon, An Elephant Doesn't Marry a Giraffe. Also, you're writing, you have, I believe, a monthly blog on divorcedeverafter.com. And you write about topics, so you can check that out. Do you have any other closing comments you want to share? And I do really appreciate you taking the time and having this conversation and really writing this fantastic book.
Yeah, I really thank you for the opportunity to discuss some of these topics. As you can tell, I'm passionate about a lot of these. And at the end of the day, I really would like to see people have the resource that they need to get them through this terrible time. And I'm hoping that my book may contribute to that, to helping them get through that. So thank you once again for the opportunity to talk about this.
Yeah. Thank you, sir. Thank you.